The big news of the week, the Supreme Court just heard oral arguments in a not a Second Amendment case, but a gun-related case, the Cargill versus Garland, dealing with bump stocks. The Trump-era bump stock ban just had its oral argument before the court. Both you and I listened to the oral arguments, and you covered it for the site. If you want to just tell us some of your big takeaways from how that oral argument went.
Yeah, this is an interesting one, right? Because we talked a lot about this bump stock case in the lead up as being very connected to most of the other ATF rule cases, right? These other ATF bans on like pistol braces and so-called ghost guns, right? Unfinished firearms parts or parts kits, and even the private sale of used guns, how they're trying to clamp down on that as well. And after these oral arguments, I am wondering a bit more about how closely connected they're going to be, because most of this case, and perhaps this makes sense if you think about it, but most of this case was very laser focused on just the actual function, the technical function of a bump stock, how it works in practice, when equipped on a semi-automatic rifle, and what exactly the definition of machine gun means in the National Firearms Act, because that's what the ATF did, right? They reclassified these devices as machine gun parts, essentially. So it said that actually the bump stock, after years of saying under multiple administrations that these were just firearms accessories, they were not machine gun parts, and they weren't regulated at all by the National Firearms Act or the Gun Control Act. They obviously, you had the Las Vegas shooting in 2017, where so the only crime that we know of being committed by somebody using a bump stock equipped gun also happens to be the worst mass shooting in American history. So that threw a lot of things into chaos from a political standpoint. And the President Trump at the time ordered the ATF to ban these devices. And the way that the ATF accomplished that was through rulemaking, where they said these things were actually always illegal. And so, it's illegal for you to possess them. We'll give you a grace period to turn them in or destroy them. And after that, you will be a felon if you are caught with one. Now, most people did not either turn them in, or at least they didn't turn them in. Nobody, who knows what people did with them exactly. But, and there haven't been, I don't think there have been any federal prosecutions over this that I'm aware of. There have been some state level prosecutions under laws that were created that sort of mirrored this ban, but I don't think there have been any federal prosecutions. But regardless, that's how the ATF got to the ban, was saying, well, actually, these things are machine guns. And so the court case, the oral arguments, were almost entirely about like what the definition deals with if a gun can fire automatically more than one round after a single function of the trigger, then it's a machine gun, according to the NFA. And so most of this was focused on function of the trigger and what exactly that means. And that it was pretty laser focused on that. And it got pretty, I think at certain points, the justices, things got well beyond their grasp of how firearms work. And so you got into a lot of hypotheticals and black box guns. And, well, what if you have to press several buttons to make it fire automatically or something? And it got pretty convoluted at points. But they were almost entirely focused on this question of what is the function of a trigger? What does that mean? A function of the trigger, a single function. And so, it didn't really focus much on the sort of flip-flopping, which we talked about in a lot of these other cases. The ATF has kind of changed its mind over the years about what a pistol brace is, or what's a finished firearm part and what's not regulated unfinished firearm part, or what is a bump stock. So there was a little bit of talk about that, especially from the conservative justices, but it was almost entirely this examination of the definition of function, I guess.
Yeah.
I don't know. That was my takeaway from watching it. What about you or listening to it?
Yeah, it for sure got into the weeds pretty quickly. As you said, I think we got to a point very quickly where we exhausted the justice's knowledge of firearms and sort of the mechanics of firearms. And it became very apparent by some of the questions and the hypotheticals. But another big contextual
and they would say
clue,
that they were confused a number of times. Yeah. They were just like, I'm confused about what's happening.
Right. Which, in its own right, maybe is a tell about where this comes down, right? Because some of the arguments that have been made, at least at the lower court levels, is like, well, when there's ambiguity in statutes, does the tie go to the runner? Basically, does the tie go to the average person over the ATF? So we'll see if that makes a difference, but it is telling that uncertainty came. But
the rule of lenity, it's interesting they didn't actually specifically talk about the rule of lenity, because that's where that would come in.
Right.
And maybe that's because it would apply in a criminal case.
Right.
If someone was actually arrested over this and went to court, the rule of lenity would probably come into play. And the lower courts did explicitly talk about that point, but it wasn't much of that discussion in the actual oral arguments, at least not explicitly where they literally said the words rule of lenity.
It could be maybe, I don't know if rule of lenity was excluded from the question presented when the Supreme Court granted cert. And so they're only very narrowly deciding if the technical definition meets the NFA.
That is how the question came out. It was, that's the only question that was at play. And honestly, the way the question was written, it sort of almost assumes that bump stocks are machine guns in the language that it used. So that, I don't know. It's interesting, but so the question doesn't talk about rule of lenity, but they did talk about the flip-flopping and the sort of legal peril that puts a lot of Americans in. And the government even sort of conceded on several points about that, that if they did bring charges, these would be a big problem for them. But it was interesting not to hear them talk explicitly about the concept of the rule of lenity and almost entirely focus on what the heck function of a trigger means.
But I also think one thing that was very clear was the practical concern that a lot of the justices had, even on both sides, both the conservative and liberal justices, were very clearly uncomfortable with what bump stocks do, whether or not they agree with the ATF's interpretation. But you heard even Justice Barrett say, like, it's clear that we don't want these rapid fire things on the streets, but I'm just struggling to see how the definition fits. Or you hear about even Justice Gorsuch talking about, okay, we want machine guns to be banned, but are these machine guns? So I thought that was interesting. And I think people need to realize that I don't think any of the justices are comfortable with automatic weapons and machine guns and that sort of a thing. It's just a matter of finding, can the ATF actually classify these accessories as the same category under law as a machine gun?
Yeah, and I wrote a members piece about this, going into like where each justice seemed to come down based on the questions they asked. Now, look, we're interpreting the oral arguments here, right? And that's always a bit tricky because you don't know exactly why a justice is asking a question the way they are. They don't always come out in the written opinion the same way they might have sounded in oral arguments. You can kind of try to read the tea leaves, and I think in this case, it was particularly difficult to figure out where the majority is going to be because you had now one thing I'll say is like it was clear that they were focused on this particular question about what function of the trigger means and how exactly bump stocks work practically. And then I think it was also pretty clear where the liberals on the court stood, which is that they either thought that bump stocks do fit into the text itself, or like you noted, they think that it's within the spirit of the law, I guess you would say. Like there was a lot of focus on rate of fire, that bump stocks can help you reach a rate of fire that is similar to a machine gun. Of course, you can also do that without a bump stock by just bump firing, which the government did admit, and there were several questions about that. But they were much more concerned about rate of fire, it seemed like. And certainly all the liberal justices, I think, they're plainly going to be on the side of the ATF. That's, I think, is fairly safe to say, reading the oral arguments and listening to them. But the conservative justice, on the other hand, is a little less clear. To me, I thought Gorsuch and Kavanaugh, even though, like you mentioned, they both explicitly said that they think these things should be banned, or at least they agree with the concept of banning them. Which is interesting, yeah, for the point that you're making, that it's very unlikely that, I know a lot of people, sort of an ancillary point, but I know a lot of people, especially gun rights activists, will read Bruin and think, wow, this, you can even hear gun control activists talk about it this way as well. This really imperils a lot of gun laws. And of course, the NFA, and in particularly the Hughes Amendment, which banned new sales of machine guns back in 1986, is a particular thorn in the side for a lot of online gun rights activists, I would say, people who are very, watch a lot of gun tubers and probably listen to the show or something like that too. That there's a lot of opposition in the activist community against the National Firearms Act and machine guns that I just don't think is shared by the Supreme Court at all. Obviously they made a specific carve out in dicta, not it's not binding, but in dicta that banning things like M16s, fully automatic weapons, is fine, or at least it's not being questioned by Heller. And this case is another example of, like, I don't think the court is going that far down the path of just eliminating all gun laws because it's hard to imagine a historical justification for them, even though that might be how you should read Bruin. Obviously, people have very different opinions on how you should read Bruin, but obviously, certainly you can get to that conclusion of, there's no history or tradition. There weren't bans on these sorts of guns at the founding. I mean, of course, we're talking about guns that didn't exist at the founding. There were some analogs to some degree at the founding, but the Maxim machine gun didn't come along until that sort of automatic fire didn't come along until the late 19th, early 20th centuries. So, if at the very least, there's any indication, as an aside here, that the justices are not, even the more conservative ones, are not likely to be on board with fully automatic weapons. But regardless, Gorsuch and Barrett both explicitly said that they agree with the idea of banning bump stocks, really, presumably in addition to machine guns. But they also seemed the most skeptical of the government, honestly, because they said, yeah, maybe these should be banned, but I don't think the statute actually does that. And that was a problem for them.